President Nelson Havi, you submitted a memorandum. You can also maybe just share with us key highlights.
Thank you.
And then you can also, thank you.
Thank you, Madam Jacqueline Ngutia. I would have been glad if the members of the council had highlighted, just in brief, for us to know what they have done, because speaking for myself and the majority of the members of the Law Society, we are not aware of how the council collected the views and how it presented them. But that notwithstanding, I've set out 5 issues which I'm of the view, if incorporated, will better these regulations. The first issue relates to regulation number 2. It is important that the decision of the Commission be defined with elaboration. And this request is informed by the fact that in the recent past, we have never seen a decision of the Commission recommending that a complaint submitted to it does not disclose a ground for removal of a judge. Of course, we've seen many where the petitions have been forwarded to the President to constitute a tribunal. Good order and constitutionalism only requires that there be a reasoned, signed, written decision by the Commission dismissing petitions. Number 2 is in respect to decisional independence. We've seen as the objective of the regulations under Regulation 4, emphasis has been made on decisional independence. With tremendous respect to the members of the Judicial Service Commission, this concept called decisional independence has been coined during the tenure of CJ Martha Koome as chair of the Judicial Service Commission. Before then, it was not there. And it's important that we protect the independence of the judiciary whilst at the same time ensuring that there is integrity and accountability. There is no constitutional anchoring upon which this decisional independence can be brought in through subsidiary legislation. It is therefore my humble request that we remove the entire decisional independence as one of the overriding objectives of these regulations. Number 3, under regulations 29 and 46, there is a delegation of the powers of the Commission under Article 172, sub-Article 1 and C of the Constitution to the Chief Justice. Speaking for many magistrates who have acted before the Commission and also in courts, the delegation of this power is not permissible as a matter of law, because those are the powers of the Commission itself. They cannot be delegated more so through subsidiary legislation in the manner in which it is intended. And in any event, this power has been abused before. I've indicated the case of Brian Haemba, and there are many other cases that have been determined by the High Court and the Court of Appeal.
We lost you, Emeritus.
Oh, are you able to hear me now? Madam Jacqueline Ngutia, can you hear me? Is it just on the part of the Commission or the entire membership of the platform? No, I'm not done. And I hope nobody's trying to mess up with the transmission.
As we wait for Emeritus to fix his system, maybe we can get another person to share their views.
Madam Jacqueline Ngutia, okay. I'm still here.
Okay.
I'm still here.
Right. Okay. Please proceed.
So I was elaborating the many cases where this power has been abused by the Chief Justices, and it's imperative that this power, which is pivotal insofar as magistrates are concerned, be exercised only by the Commission itself in the same manner that it will exercise while receiving complaints in respect of judges. That is number 3. Number 4, there is that limitation imposed of 3 years under Regulation 64. I believe there is no need to put a fetter to the unlimited right to forward a petition for the removal of a judge. These are the reasons. One, it's unconstitutional in the first place. Number two, the incompetence, misconduct, or misbehavior of a judge of the superior court often will become manifest after exhaustion of the appellate processes. An appeal to the Court of Appeal takes an average of 5 years. An appeal to the Supreme Court an average of 2 years. Bearing in mind all eventualities, it may take as much as a combined 10 years for you to overturn a decision of the High Court. There is therefore prudence in removing the entire Regulation 64. Number 5, we are in the digital era, and I remember on 1st July 2020, CJ David Kenani Maraga inaugurated the online platform that we are using now. And it took so many days of deliberate effort and determination for us to set up that system. It cannot be that the Judicial Service Commission will want to divert and fail to incorporate an e-filing platform. I therefore propose that there be a specific part where e-filing is acknowledged in the regulations with elaboration that the petitions, responses, affidavits, statements and submissions, directions and decisions of the Commission will be uploaded there for accountability and integrity. For the brevity of time, permit me to limit my proposals to those 5, which I think, if incorporated, will go a long way in bettering these regulations. And lastly, may I thank the Judicial Service Commission for taking this long-awaited initiative of coming up with these regulations. They were long overdue.